This is WZRD Chicago 88.3 FM. And we have with us at WZRD via Zoom, Justice Cynthia Cobbs. Good morning, Justice Cobbs. How are you today?
Good morning. Good morning. I am well. I'm well and happy to be joining you this morning.
Wonderful. There is so much to talk about because when we have an election of judges, and there's that whole big list of judges on the back of the ballot. It's like about 100 names. It's so hard to know who is who. But let us talk about you. First of all, you're currently a justice at the appellate court, District 1, and you were appointed, and now you're trying to get elected to retain your seat. What does District 1 cover?
So thank you for asking the question. I am, as you said, a justice on the Illinois Appellate Court, where I've been serving on the appellate court now for 9 years. So most folks, when they hear us talk about which district on the appellate court we serve, have a question just as you do. So I'm happy to answer it. The first district, Illinois Appellate Court, covers all of Cook County. So on election day, when you go into the ballot box, you will see only names. If you're in Cook County, you're going to see only the names for judges or justices who are running in Cook County.
Mm-hmm. And nowhere else. It doesn't cover anything else, right? The District 1.
Just Cook County. Cook County is the largest district, is our largest judicial district in the state. So there are 5 districts, judicial districts, but the first judicial district covers only Cook County.
Mm-hmm. And then how many judges serve with you at District 1?
So on the Illinois Appellate Court, there are 24 appellate court justices. And as you know, we sit in panels of 3. So on every case that's appealed to the Illinois Appellate Court, regardless of which district, but we're talking about the first district, Cook County, this morning. Mm-hmm. So on every case, there are 3 appellate court justices who will decide the appeal.
Mm-hmm. So that means that in District 1, there are always at least 3. What if one of you gets sick? Are there any backups?
Well, if you get sick, that doesn't really disqualify you from doing the work. So there are 6 divisions, and in every division, there are 4 justices. So we're randomly assigned cases to either author or to serve as a panel member. So even if one justice in the division, which is 4, even if one justice gets sick or can't participate for any reason, whether it's sick or they just need not to participate in a case, mm-hmm. we still have 3 justices to choose from. And if by some odd chance, all 4 justices in a division can't serve, then you find 3 other justices out of the whole 24.
Oh.
So we can usually find someone to sit on an appeal.
So what you're saying is that there are 24 justices in the appellate court throughout the state, and then
first district,
just the first
Cook County.
Oh, okay. And then how many divisions are there again for Cook County?
So in Cook County, the first district, there are 6 divisions.
Oh.
And each of the 6 divisions, there are 4 justices. And on every case, 3 of the 4 will serve on every case, on a case.
And what about the divisions? Are the justice assigned to a certain division, or is it random? Yeah, you might serve at first division, second, third, fourth, fifth, or sixth.
So when you first come onto the appellate court, you're assigned a number. So my number is number 4. So the other justices in my division are 1, 2, and 3. I'm number 4. So that tells me, or that tells the court, which district or which division I am going to serve in.
Which is Division 4?
I am in Division 2 right now.
Oh, okay. So you're number 4 of the 24, and then yes. You serve in Division 2. But yes. If necessary, you might get moved into Division 3.
That's right. If I'm needed to participate in a case because, for some reason they can't find 3 justices in another division to hear a case because either there's a conflict or someone, as you suggested, might be ill and out, sometimes you might get asked to serve with another division in the first district on a case. even though it's not in your division. So it sounds a little complicated, but it works out. It works out.
Definitely. And then for the division, so if how many cases are there? A lot of cases for every division, or are some divisions more heavy in cases than others?
No. What happens is cases are assigned to the first district based on the number of appeals that are filed from the trial courts in Cook County. We are randomly assigned cases. Every justice is randomly assigned to be the writer or the author of the opinion or the decision, but it's all random, and it's all intended and works out to be equally randomly distributed among the 24 justices on the court.
What,
So you don't get to choose your cases. They are randomly assigned.
How who does the random assigning?
It's computerized. It's computerized. It's computerized.
And it has been computerized since when?
Oh my. I used to serve as the director of the Illinois courts way back in 2002, and it was computerized even then. So there is a computer generation system that is operated out of the court's administrative office in Springfield. And so as notices of appeal are filed, that information is inputted into a computer system, and then it generates really cases and assignments for all of the justices throughout the state, but it does it by district. So it's random. You don't get to choose your case. You don't get to choose, anything really about that.
Even the attorneys, when they file their briefs and the appeals, they can't choose like what division their case lands in.
No.
They just file to the appellate court.
That's absolutely correct. You have no ability to determine which division in the appellate court is going to be assigned the case. You have no ability as a lawyer to decide which justice is going to be assigned to author the decision. It is all random. The justice who is assigned the case or who is on a case may recuse him or herself if that justice believes that, he either knows the litigants, knows the attorneys, has some interest in the case or the outcome of the case. Then we have recusal, and we rely on the justice to exercise their right or the privilege of recusal without any interference from attorneys or anyone else.
What about the rulings of District 1? In what ways would they affect other districts?
So even though we stand or we sit as one appellate court, and even though there are 5 districts throughout the state, the trial courts in the first district are bound to follow the case law, the decisions that are rendered by the first district appellate court. Outside of the first district, our rulings in the first district are instructive or persuasive. Other districts do not have to follow our case law or our decisions. They may follow them, but we're not required to follow them. So if you're in the first district, then you're a trial court in the first district, you're bound to follow the first district appellate court's rulings. If we've not ruled, then you may look to other districts' case law to determine which law will apply to decide an issue or a matter before you.
And when your law clerks do research on cases, that's the research that they do, right? On case laws and precedents and all that.
They do. I happen to have been a law clerk before I ever became a judge. I was a law clerk on the Illinois Supreme Court and on the Illinois Appellate Court. So it's kind of interesting that I am now serving as a justice on the same court that I started being a law clerk. But the work of a law clerk is really, really critical and essential to the work of the court and the judge for whom the law clerk works. They do read the records, the report of proceedings or what was captured in the trial court. They do the research of the cases that are cited. They converse or they have conversation with the justice for whom they work. We talk about the research. We talk about what the state of the law is. We talk about the facts of the case, and then we talk about what the outcome likely should be based on the case law and the facts. So law clerks are critical to the work of the justices, but it is a give and take. It's an exchange. It's a communication to arrive at the right decision on appeal.
When you were a circuit court judge, what was your work as a circuit court judge?
I'm glad you asked because everybody knows, I think, that when you first become a circuit court judge, you start your judging or you start your career right in traffic court. So I started there just like every other judge. You start in traffic court. And then from traffic court, I was assigned to work in the first, continue my work in the first municipal district. So I was hearing breach of contract and subrogation claims. I also did a little work in evictions court. And then ultimately, though, before I left the circuit court, I was assigned to hear civil juries. So civil jury matters in First Municipal involved really insurance claims or subrogation claims, those type of issues. So I had a reasonable portion of practice or experience in the trial court. I didn't stay as long as some, but I had some experience there that prepared me for my work or helped prepare for my work on the appellate court.
What is subrogation?
Oh, subrogation really comes up in insurance cases. For instance, if there's a car accident and then your insurance company pays the cost to have your car repaired, then the insurance company will sue whoever really is responsible for the accident. And that's really the nature of subrogation. It's kind of in a nutshell and kind of condensed, but that's basically what it is subrogation.
So everybody, all the new judges are assigned to traffic court. Is it on account of the traffic court having the heaviest caseload?
Well, traffic court is a court of high volume. It's a high volume court, but generally it's been perceived that new judges really cut their teeth, really become engaged in the judicial process, or really become more familiar with the judicial process, or being a judge in the traffic court arena. So we all go there. They say you really do kind of like develop your judicial temperament because it's a high volume court call. You see all kinds of people, all different races, all different ethnicities, all different socioeconomic, ranges come before you in the traffic court. So it's a good starting place for every judge to kind of like get his or her feet wet.
What happens if those ethnicities, the defendants or the plaintiffs, don't speak English? Does the court have translators for those people?
Yes, they do. Even outside of traffic court, and I'm talking only about Cook County. In Cook County, if there is a litigant, if there's a litigant who comes into court and they indicate that they need an interpreter for whatever the language is, if there's an interpreter there in the courtroom, we can get them there quickly for the matter that's up. Otherwise, we can continue it, or we have continued it until such time as we can get a translator and interpreter in the courtroom, because it's important that whoever is standing before the judge understands the nature of the case. So yes, there are interpreter services that are provided in the Circuit Court of Cook County.
Do you still remember what language was the hardest for the court to get an interpreter or translator?
Oh my. Well, I don't know what was the hardest, but I know that we have a wealth of when I was in the trial court, we had a wealth of translators for Spanish. We had Polish. Now, some other languages, it might take a little longer to find someone because you wouldn't necessarily have someone in the court facility, because there are so many different languages that it would just really take the court maybe, a day or so to locate somebody that would be able to come in. Now, that may have changed because I've been away from the trial court now for 9 years. I've been on the appellate court for 9 years. And so I can only hope, though, that it's gotten better, not worse. But it was pretty good when I was there.
And when you say that you're trying to find someone within the facility, do you mean to find someone that is like that actually works there, that happens to know a second language?
That happens to be housed in the trial court, in the circuit court. So there may be an office there. So for instance, in traffic court in particular, there are a lot of individuals who come in the traffic court. We know that we have a large Hispanic population in Cook County. We know we have a large Polish population in Cook County. So those interpreter services are probably easier, and you can likely find them in an office there in the Circuit Court of Cook County, in the building.
You served as a staff attorney and then as chief legal counsel in the administrative office of the Illinois courts, which is the administrative arm of the Illinois Supreme Court. Then in 2002, of course, you were appointed by the Supreme Court as director of the Illinois courts, becoming the first African American and the first woman to serve in that capacity. What did the work of staff attorney and director of the Illinois courts entail?
Well, the administrative office, as you already indicated, is the administrative arm of the court. So our Illinois Constitution requires that the Supreme Court oversee all of the courts in the state of Illinois. To do that, the Constitution also requires the Supreme Court to appoint a director. As the director, you work closely, and I work closely with the Illinois Supreme Court, the 7 justices on the Supreme Court, in overseeing and administering the court system. So it is really a range of issues. It ranges from judicial education for all judges. It can involve personnel policies for state-paid judicial employees. It can involve the delivery of probation services, the management of the Supreme Court's budget, anything that you might imagine that it would take to oversee a branch of government was the work of the director in tandem with the Illinois Supreme Court. That was my work. The administrative office also has a cadre of attorneys. So when I was chief legal counsel, it was my responsibility to oversee the work of the attorneys who worked in the administrative office. And we could not go to court because when you work for the Supreme Court, you can't practice in the traditional way, so you can't appear in court. So the Attorney General's office is really the lawyer for the Supreme Court. You relate to, or you have conversations, or you engage with the Office of the Attorney General when they needed to go to court on behalf of the judicial system. But we would be involved in talking with the Attorney General about those matters. There also was a fair amount of transactional work. There are leases, there are contracts for equipment, there are policies, sexual harassment policies, personnel policies, and claims. Those are the kinds of matters that are managed by the director, overseen by the director, and as chief legal counsel, more directly overseen on behalf of the court.
Supreme Court Justice Joy Cunningham told me that half of her work, well, a lot of her work is administrative, and it really, really keeps her busy. So yes. What does the director of the Illinois courts do that is different from the 7 Supreme Court justices? Because all of you, all 8 of you are so busy. What are the different duties among you?
The work of the director is actually in tandem with the Supreme Court in administering the court system. So they of course have the added work of making certain that vacancies on our court systems are filled. They also have the added responsibility of making certain that there are boards and commissions and committees that are working to support the work of the court system. In that regard, the administrative director would be responsible for facilitating the work of those boards and commissions. For instance, as the director, I might assign an attorney or a staff person to work with a Supreme Court committee or a Supreme Court board. I might assign an attorney or an employee in the administrative office to develop some protocols or some policies for the work of a committee, and more particularly in the judicial education division, because we educate our judges, we require our judges receive continuing judicial education. The administrative director would have oversight of the education division, and the education division, before we had a judicial education college, would be responsible for developing with judges throughout the state continuing education courses. So that's some of the examples that the director would be responsible for, but always in tandem, in collaboration with the justices on the Illinois Supreme Court, because that is that work, administrative and supervisory.
You mentioned personnel. So if there were vacancies, then the Supreme Court justices would try to help fill them. But would it be you and your department that would do the search and find the candidates and interview the candidates?
Not for judicial vacancies. Judicial vacancies really are managed by the Supreme Court without really any involvement of the director of the Illinois courts. Mm-hmm. But there are more employees, or there are more people who work in the judicial branch than judges.
Right.
So in the administrative office, for instance, there are several divisions, and those divisions are headed by assistant directors, and under the assistant directors are staff. So the director would be responsible for those type of staffing issues. Judicial vacancies are handled by the court.
Okay, so so you handle totally all the personnel that are in the office, and the justices handle the justices. So so they don't have any hand in personnel except for the justices, for their fellow
In
justices.
personnel, they hire their own staff. They have law clerks too. They hire their own law clerks. And to the extent that there are other offices that are directly under the Supreme Court, for instance, the Marshal's office, which is largely responsible for security, the Supreme Court hires their own marshals. The director of the Illinois courts may do a search on behalf of the court for to fill certain positions, but generally the court can fill its own positions without the aid. But the administrative director works in tandem to assist the court in administering the court in any way that the court would seek to have the director involved.
I still don't really understand it. I know that you work together, but then how do you help them? Just to give us maybe 2 examples of what they need, and then how you back them up.
So let's just talk about budgeting.
Okay.
So the Supreme Court has an annual budget. Now I haven't been the director now since 2011, so I hope it may have changed over time. But when I was the director, it would be my job to develop the budget for the Supreme Court, which was the budget for the judicial branch for the state.
And how much would that be at that time in 2011?
At that time, it was close to 300 million. So it would be the director's responsibility to develop the Supreme Court budget, to appear to go to the legislature with the Chief Justice to present the budget to the legislature. But then once the legislature approved the budget, it would be up to the director to oversee and administer the budget, to make certain that money was spent, and that money was spent in the way that it was supposed to be spent based on our presentation of the budget to the legislature. So that's one thing, it's managing the budget. The other thing is the Supreme Court has several committees, commissions, and boards. It would be the responsibility of the director to make certain that we had staff from the administrative office working with those committees and commissions that were created by the Supreme Court to ensure that the work, the assignment, the task that the Supreme Court assigned to that committee was being done, to aid them in any particular way that was necessary to get the work done.
Could you give us some examples of those committees and commissions and boards?
Sure. I'll tell you, some time ago, the Supreme Court, and it was then Chief Justice Thomas Fitzgerald, created the Committee on Evidence. And the role or the goal of the Committee on Evidence was to bring together all of the rules of evidence, wherever they might be found, in common law and in case law, to bring them all together and to compile them as one set of rules of evidence that would be applicable, or that the practicing bar would apply in litigation. That's one example of what it would be. Another example would be, let's see, back in, I think it might have been earlier than 2010, but there was the adoption of minimum continuing legal education for attorneys, because as you know, the Supreme Court is responsible for overseeing the practice of law. So there was a committee that was put together to look at rules of practice, or to look at the rules that would apply for the development or for the implementation of continuing legal education. So I was responsible as the director to assist in identifying someone who would oversee the entity for the continuing legal education. There are a wealth of matters, because it's just there's a lot of work that goes on to administer a branch of government.
And a major task of what you did was education, making sure that the judges and the attorneys had enough knowledge that has changed after they've went to law school, that they need in order to practice law.
That is certainly one component of what the director's work would be. The other component, I mean, we had a big IT, information technology. So the administrative office was responsible and is still responsible for making certain that the Supreme Court's website is up and running, for making certain that there are computer systems operating, that all of the state paid judicial offices are operating with the necessary computer equipment that they need. Email, all of that. The technology piece was there as well. So there are a lot of issues. We oversaw what we call the manual on record keeping for the circuit court clerks. Circuit court clerks have codes that they put on cases. Those codes are generated out of the administrative office. That work is also overseen by the director. So there are just a myriad of things or issues that are managed by the director of the Illinois courts on behalf of the Supreme Court, some directly involving the justices of the court, but some that the director is responsible for to just make certain that the day-to-day operations of the judicial branch are going on.
Could you give our listeners some example of continuing education, like the trends that are applicable now, and what is it that that lawyers and judges suddenly need to know that maybe a year ago it wasn't on the horizon?
So let's just take continuing judicial education, for example. So whenever there are new statutes that are enacted by the legislature, there may be, and there will soon be, what we call education conference beginning for judges here in the state, actually this month. So when you go to continuing judicial education, you're required to complete 30 hours of continuing education every 2 years. You may be instructed on new legislation that impacts the judiciary. So for instance, the Pretrial Fairness Act was recently enacted. We call it the Safety Act. So judges have been and probably will be at EdCon or Education Conference instructed on really all of the particulars of that new law, what impact it has on the work of the judiciary, and some time frames that it takes for judges to decide cases that come before them for defendants who are seeking not to be detained, and how those cases will work their ways up in the system. We may also be instructed on how to interview children in child protection cases, children who are alleged to be abused or neglected. We may be educated on certain Supreme Court rules on the dismissal of cases. Any type of issue or any type of subject matter that could impact the work of a judge could be the subject of continuing judicial education.
For the Safety Act, a lot of the act is not actually very clear yet. So how do the judges in their continuing education address that? Because what I've heard from other interviews, a lot of the details of the Safety Act have not been fleshed out. So how do judges decide cases if some parts of the act are still unclear?
Well, it is always the responsibility of a judge to construe or to interpret a law clearly and to attempt to construe it or to understand it or apply it in the way that they believe the legislature intended it. So we have in the judicial branch and in law what we call the plain language of the statute. So we first look at the plain language. If the language is clear, we can apply it. If the language is unclear, then we have to attempt to understand it based on age. We may look at the legislative history, what the legislators have said about that piece of legislation as they were continuing to decide how to enact it or how to draft it. So there are ways. We look at the language, we look at the legislative history, meaning what the legislators have said about that piece of legislation when they in fact were drafting it.
And by now, have you seen any changes in the interpretation of what the law was earlier, and then later as different cases came up, like maybe defendants that the shooter should not be detained? How has the Safety Act evolved in the district court and appellate court, do you see?
So I can only speak to you from the perspective of the appellate court, which is where I sit. And we
Okay.
have we've seen several appeals coming up from the trial court involving either the denial or the grant of bond for defendants. And in those instances, we've not found, at least in the first judicial district appellate court, we've not found any lack of clarity that requires us to construe the act. The act to us is clear enough for us to apply it. And so we have decided several appeals now where judges in the trial court have either allowed or denied bond for the defendant. So at this juncture, I can't say that the statute is in any way unclear for our purposes, at least. It certainly could be the case in the trial court that there is an argument to be made that, but I have not, as an appellate court justice now, who I've had maybe about 9 appeals of decisions arising out of application of the Safety Act. I've not seen any lack of clarity in the law. We talk about how it should be applied. We talk about what standard of review should be applied in resolving the appeals, but generally, we have not found in the first district a lack of clarity in the language as it relates to our work in deciding issues that come up on appeal.
You also, as director of Illinois courts, you had to advise on the rules of practice for attorneys. Can you give us examples of these rules of practice?
Sure. So the Supreme Court has what is called rulemaking authority. So you'll find it in Supreme Court Rule 3. The Supreme Court makes rules that govern the rules of practice for attorneys when they come into court. So for instance, in the appellate court, there are a series of rules that apply to litigants that either tell you when your brief in a case is due. It will tell you, the rule will tell you how long your brief can be, how many pages it can be. It will tell you how the brief must be divided into a fact section, into an argument section, and the like. It will tell you how many days, the rules will tell you how many days you have from the time you have a final judgment in the trial court to when you must file a notice of appeal. Or from when you have a final ruling from the appellate court as to when you must file a petition for leave to appeal in the Supreme Court. So those are examples of rules of practice. From time to time, not necessarily those rules that I've outlined here, but from time to time, rules of practice may need to be amended. They may need to be changed. For instance, now we are in a world where we are e-filing. Things are e-filed. 20 years ago, paper was filed, and you had a certain number of days to get your paperwork into the clerk's office. Now, under e-filing, you have till midnight of the night before the night of the deadline to get something filed. Those are the kinds of things that are called rules of practice. And from time to time, to keep up with changes and advances, like from paper filing to e-filing, it requires an amendment to Supreme Court rules. And the director would be involved or would be working with the Supreme Court's Rules Committee as the secretary in looking at the various rules and deciding whether any of the rules needed to be amended. And if so, when I was the director and when I was chief legal counsel, more particularly, I would be the individual who would go in and meet with the Supreme Court to talk about proposed amendments to Supreme Court rules.
Could you give us an example of an amendment?
Sure. So there is an amendment that there is a Rule 39. Rule 39 deals with the appointment of associate judges. Rule 39 is a rule that is administered largely by the director of the Illinois courts in collaboration with a chief circuit judge. So for instance, in Cook County, it would be Chief Judge Evans. At one time, there was not language in Rule 39 that dealt with residency. So we needed to amend the rule to make clear that to apply for an associate judge position, you needed to reside within the district in which you were applying to be an associate judge. So that's just a simple one. There are lots of amendments because there are lots of rules. If you go into the Supreme Court's website, you'll see that there are lots of rules that govern the practice of law.
As these rules, are they were they begun by the legislature, or were they just uh, uh, came out of a committee as a as an aid for the practice of law?
Well, they're not aids. Rules have the force of law.
Mhm.
So the Supreme Court the judiciary is the third branch of government.
Mhm.
And as the third branch of government, the judiciary has oversight by constitution, oversight and administrative authority over the judicial branch of government. So those rules don't emanate from the legislature. That's not to say that there are not statutes also that may impact the work of the judiciary. But the Supreme Court has administrative and supervisory authority and rulemaking authority to govern the practice of law and to govern matters and issues that are confronted in the judicial branch of government. So rules come from the third branch of government. Statutes come from the legislature. And we have in our government separation of powers. So no branch can overly intrude in the work of another branch. So that's why the legislature can set statute on sentencing, and the judicial branch applies that law.
Mhm.
Right? So you have three branches of government. Legislature makes the law, the judiciary applies the law.
Well, thank you so much for the clarification. I never understood the rules. So evidently, all those committees and commissions and boards that the Supreme Court uh, appoints, those are the committees, let's say on Chicago City Council, that debate on different pieces of legislation, on different ordinances. Those committee, commissions, and boards are going to be debating on rules, right? And then if it comes out of the committee, commission, or board, then it goes to the Supreme Court, and the Supreme Court votes on whether or not to pass that rule.
That is an accurate statement of what happens with a rule, with the Supreme Court's Rules Committee. There are, and that's just one aspect of the work of the court. But you're right. The example that you drew, there is the Supreme Court Rules Committee. That Rules Committee will take up proposals to amend certain rules. They will research it, discuss it, talk about it, hold public hearings on it to see if there should be an amendment to the rule. And if they think there should be, then they make a proposal or recommendation to the Supreme Court, and the Supreme Court will then decide whether to amend its rule.
How do new rules come before these committee, commissions, and boards? Is it just the Supreme Court and the court itself, or are there attorneys or even lay people that actually find something that affects them, and it seems as if the rules need to be changed, and then submits that rule for consideration?
You'd be a great candidate to work on the Supreme Court Rules Committee because you know the process better than most. So you're absolutely right. A proposal to amend the Supreme Court rule could come from an attorney. It could come from an office. It could come from the state's attorney's office. It could come from practicing attorneys. It could come from lay people who are not in the law but who understand how a rule works. Anybody really can, if they're aware of a Supreme Court rule that impacts or that applies to the practice of law, anybody can submit a proposal to the Supreme Court's Rules Committee, and the Rules Committee will determine whether or not that rule should be set for public hearing, whether they should continue to research it to make some determination as to whether or not they should set it for a public hearing. They invite everybody. It's a public hearing. Anybody can come to a public hearing. And if you want to make comments about a proposal, just pretty much like what you described earlier, make suggestions or talk about why they think a rule should be amended or why they think a rule shouldn't be amended. And then the Rules Committee ultimately will take all of that information and make a recommendation to the Supreme Court as to whether to amend or not amend.
And do you have any examples of community people that have submitted suggestions, amendments, or rules? And also, is there anywhere on the court website where the community can find upcoming public hearings on these rules?
Sure. I'm not going to be able to give you a suggestion right now. I've not been in the director's seat in some years, but I would point people to the Supreme Court's website. And on the Supreme Court's website, you should be able to find on there in the menu something about rules. And if the public hearings don't happen constantly, they are set. And when they are set, they're made public. There is publication made on the Supreme Court's website, and notices sent to all of the courthouses in the state. And I think it's even published in the Chicago Daily Law Bulletin when there's going to be a public hearing on proposed rules amendments. But anyone can access the website for the Illinois Supreme Court, and just there's a drop down menu, I'm sure, for rules. And if you drop down, or it might be Rules Committee, if you click on that, you probably can find more information about when there might be a public hearing, or when there was the last public hearing, or any other information that is a public that the public can be made aware of.
Can you give us an example of an amendment or rule that maybe an attorney or even a community member might have suggested, might have introduced, so that at least our audience has a grasp of the process?
Well, I won't know a rule that's happened recently because I've not been involved in the rule. So back maybe several years ago, there was a proposal to allow a rule to keep confidential the names of individuals who might come before the court in what would be a case involving child abuse or neglect. And the rule sought to keep the names of the children, and sometimes the parents as well, if it was telling, but keep the names of the children anonymous just by using initials, the child's initials. And that rule was adopted by the Illinois Supreme Court. And now you will see in a child protection case, or cases involving children who might have been abused or neglected, you may see a motion to keep the names of those children anonymous, just using initials, so that the public could not easily determine who the subject of the litigation might be.
Are there any rules in place to protect the victims of domestic abuse if they happen to have to appear in court?
Well, you're asking me a lot of questions that would require me to really do a lot of different kind of research now. So it's like, I don't know if there are any rules in place that would necessarily do that. And I apologize had I been prepared for that. I might have done some research, but you're asking me a question now that's a little beyond my ken.
Oh, that's okay. Don't worry about it. It's just that what you have described is so interesting, because I think I know I haven't, and I'm sure our listeners have never even fathomed that this aspect of the courts, and never even thought about it being a kind of like even though it's judicial, it's legislative in a sense, and that never even appeared on my radar for so long.
Now, and you're right. I would absolutely agree with you. Most people don't really think about the inner workings of the court system, but there is so much that goes on to run the branch of government, the third branch of government, that really is not apparent to most people who come day to day to the courthouse. They know that there's a judge there, they have a case, and it's going to be decided. But no one really thinks about, well, how did the computer system get in there? Or how are the lights being paid for in here? Or who tells the lawyers what they can and cannot do in here? Where do these rules come from? All of those things go into really the makeup of running the branch of government. So you're asking really wonderful questions, and I think a lot of this will be educational for your listeners.
Yes, thank you. And for this rule making arm of the courts, every state is the same, right? But they, of course, they have their own separate rules, but every state has the basic makeup of making rules.
Well, I'm not going to speak that definitively about every state, but I will say this about every state, because I've served as the director of the Illinois courts. Every state has a director of their courts. So every state has what we call a Supreme Court or higher court, and then as a component, every court in the country has also what is called an administrative director, or a director of the court, that works closely with the court in overseeing and administering the branch of government in their state.
Good. You serve on the Board of Trustees of the Illinois Supreme Court's Judicial College, the governing body which oversees continuing education and professional development for all judges and justice partners. How is this continuing education for judges changing?
So we talked a little bit about that, and I want to make one point clear before we talk. I no longer am a member of the board. I did serve on the board, and I was quite honored to have been asked by the Supreme Court to serve as one of the board members. And my term on the board has concluded. It really is a major undertaking to educate more than 900 judges in the state of Illinois every 2 years, and to ensure that each judge meets the requirement of achieving or attaining 30 judicial credit hours of continuing education. So back in the early 2000s, late 1990, 1997, it was hoped for, or there was an aspiration that every judge in the state would acquire at least 15 hours of continuing education. So it wasn't as strict as it is now. Now it is actually absolutely mandated that every judge participate every 2 years in achieving 30 credit hours of continuing judicial education. You must. There is something that we characterize in the state as education conference. That's where the judges will go every 2 years to intensive training at a conference, and you can select from a very comprehensive menu of courses that are offered by the education college, taught by lawyers, taught by people who are practitioners, psychologists, whatever it may take to have the judges educated in a particular field. They come together and they take courses. It's like going to college. It is like going to college. So you select your courses, you go to your courses. Sometimes the class is 1 hour, sometimes the class is 2, sometimes it's 3 hours. And sometimes there's a practice involved, but there's a lot of lecturing and a lot of material to educate our judges and make certain that they are on the cutting edge of the law and changes in the law.
But did something happen when before they were only required to fulfill 15 hours of continuing education, and now it's even mandated that they have 30 hours? Was it that some of the judges just were, as a result of the 15 hours, were not knowledgeable enough to decide cases?
No, not that at all. Everything evolves. And so back then, when, we didn't even have judicial education, it was new. It wasn't always something that even existed. And so my best recollection of it is when Justice Charles Freeman became Chief Justice. It was his goal that the judges would participate in this 15 hours. Now, it may have come before that. I don't want to give him credit if he's not do that, but my recollection is that when Justice Freeman was Chief Justice on the Illinois Supreme Court, it was his goal to have judges participate in judicial education and to achieve that 15 hours of continuing education credit. And just as everything evolves every time, you decide that you can provide more, you decide that there is a need for more, or that you want the best possible judiciary, you want the most competent judiciary. And so you decide ways that can happen. And so over time, it has simply developed where now we are at a stage where we have what we call education conference.
Why is there so much information now that the judges have to know, and have to study for 30 hours instead of 15? Is it the technology, or is there something else in the whole legal environment that is impacting us that the judges need to spend more time to learn?
Well, everything changes. So laws change, the way we do business changes. We see new things coming into existence all the time. For instance, it wasn't always the case that we could gain access even to our cell phones by using a thumbprint or a picture. So, those are biometrics. So there are new things that happen in our environment all the time. It wasn't always the case that you had legislation called Freedom of Information Act. We didn't always have that. So there are always changes that are going on. And these things that change in our daily lives sometimes will also impact what happens in our courts. So we've seen lawsuits come from individuals who, because their employer may require them to use their thumbprint to gain access to a building, and they question whether that gathering of that information was used properly. You may see a lawsuit on that. 20 years ago, that wasn't the case. But now we have to be as constant, we have to be as aware of changes in our society, of changes in things that might be the subject of litigation, so that we are ready, that we are prepared, that we are knowledgeable. And sometimes you also need to just be refreshed on things that have been in the law for a long time, right? So, I mean, not everything has changed, but sometimes there are different ways to do things. There are better ways to do things, just as with e-filing. We didn't always e-file. Judges may not always understand what e-filing requires, or or some of the issues that might come up with e-filing. For instance, if I filed my document, or I tried to file my document at 12:59 and the circuit court system was down, is that my fault, or is that the circuit court system? So those are the kinds of things that we always have to be aware of. There are changes always happening.
Yeah, I was thinking about that too, about having to file e-file. You could file at the last minute, but why file at the last minute when there's a chance that the system might be down and you won't be able to file on time?
Well, I think that's a good point that you make to all the practitioners who need to file documents. Get it done early so you don't have to run into that problem.
And also, you mentioned the Freedom of Information Act. I totally forgot to ask any of my judges this, but the BGA was complaining, the Better Government Association was complaining about how the judicial branch of government in Illinois is not subject to the Freedom of Information Act. Can you give us any insight into why that is so, and why that needs to be the way it is?
Well, again, that is legislation that the legislators have written. And when the legislators wrote that legislation, we didn't write it. We don't write legislation, we apply legislation. So when the legislature wrote that, they decided who would be subject to freedom of information and who would not. Now, the question is better asked to them as to why they thought it best to exempt the judicial branch. But just if I had to guess, there are quite a few matters that come before judges that really should not be the subject of public discourse. You brought up one yourself. For instance, you said something about what
Domestic
about,
violence?
yeah, what if there is something about a domestic violence issue that really shouldn't be in the public domain, and someone is seeking to have that? For instance, what if one of the litigants had the court seal the records, meaning keep them confidential?
Mhm.
Would anyone want information that has been sealed for the protection of anyone to be unsealed just because of the Freedom of Information Act? So I think the legislature acted wisely when they decided that the judicial branch would not be subject to the Freedom of Information Act, because, then where are the limitations as to what can be in the public domain, and what safety issues or what safety concerns arise as a result of that?
You mentioned that there's that $300 million dollar budget that was before, and
Yeah.
is there enough money for the courts to operate? Do you have enough, or is there any deficit? It seems to be so much that you need to do.
That would have been a better question to ask Justice Cunningham, because she's on the court and I'm no longer the director, and haven't been the director now for, I don't know, many, many years, since 2011. The more money you have, of course, the more you can do. We always asked for as much money when I was the director as we thought we needed to manage the judicial branch of government, to pay salaries for the judges, to pay salaries for law clerks, to rent equipment to, have in our courthouses, printers, copiers, computers, all of that. So, the more money you have, obviously, the more capacity you have to implement new programs and new issues to be decided. But I can't tell you whether there's enough money or not enough money because I no longer sit as the director, so I'm not privy. I could probably see the court's budget if I wanted to, but
But
I'm not
while
going
you
to.
while you were working as director, did you have enough money? That's mainly what I meant.
We were operating then as a deficit, and so we always had to be mindful and be careful of where we were spending money. In the court's bill, the budget bill, there would also always be money that we needed to make certain that we protected for salaries for essential staff. For instance, judges are essential staff. You can't run courts without judges, so we always had to make sure we had enough money to pay for the judges. We always had to make certain that we had enough money to pay our share or our allocation for the delivery of probation services and for the delivery of education. So where there were shortfalls, we would sometimes hold positions, meaning we would not allow certain positions to be filled for a period of time so that we could save money. So there are budget saving aspects that the director and staff apply in order not to run out of money and to make certain that we didn't have a deficit. But the legislature was always great in working with us in helping us to be able to decide whether we could do what we would call transfer money from one budget line to another budget line in order to meet certain demands. So, as long as you have a good working relationship with the legislature, and we did when I was the director, and I assume so now, you're able to manage the branch of government efficiently and effectively.
What about equipment? And when I use equipment, I see that it's so easy for equipment to break down, and that's so expensive. Did you find that an issue in the courts as well?
Well, when I was the director, and I have to keep going back to when I was the director
Of
because if
course.
things have changed, I don't want to talk about that. But when I talk about equipment, it is things like photocopy machines or, all of the things that you need to do day-to-day business. I mean, back in that time, we were using fax machines. Now we don't even know about a fax machine anymore. No one's using fax machines. Now we're doing things with email and computers. But we would have things like scanners and copiers and fax machines. Any kind of big equipment to reproduce large numbers, volumes of papers, of opinions, and that. So we didn't buy those things, you would rent them, you would lease them. So there was always contracts, and that's part of the work of the chief legal counsel. You're negotiating contracts for services, you're negotiating contracts for equipment. All of those kinds of things that you're doing. If you're doing a study, for instance, when I was the director, we did a study on salary administration to make certain that the employees in the state-paid judicial branch were being paid comparable or fair salaries. So we did a study. You pay for those kinds of things. So there is a way to manage the budget. If you're a good manager, you can manage it, and you come out, and you're none the worse for the wear. But it takes the collaboration of the judicial branch and the legislature. And when I was the director, I was fortunate enough to enjoy that.
When we spoke earlier about continuing education, we mentioned that there was also continuing education for justice partners. What justice partners are we talking about?
That's often a confusing term. So we know that it takes more to run a branch of government than judges, right? So every time you have a case, you have lawyers. You might have lawyers from the public guardian's office. They would be a justice partner. You might have lawyers from the public defender's office. They would be justice partners. You might have individuals from the clerk of courts. Those are justice partners. Any entity that might be involved in the disposition of a case or cases, those are justice partners. Those are individuals with whom the judges rely on, depend on sometimes to get the work done. We can't get a case unless we have the circuit court clerk sitting there kind of like putting together the records and transmitting the records. We can't do it. So we don't know all of the information about children who might be in the child protection system unless we understand what the public guardian's office does. They might be involved in helping us to understand some things. So those are what we refer to generally as justice partners. And there are more than that, but that's just an example.
So all these justice partners, are they also required to have 30 hours of training every 2 years?
We don't control justice partners. So the Supreme Court has supervisory and administrative authority over the courts, which means judges and its staff. So we do not control the public guardian. Whatever their education requirements are, they are. We do not control the state's attorney's office, the Cook County State's office. They're not under the court's control. So we have administrative and supervisory authority over courts, which are really judges, lawyers, and the staff that work for us.
And when you mentioned that every 2 years they have to be educated, so it's staggered, right? When a judge enters office, then maybe 2 years later, he or she needs to get additional education. It's not like the whole group of all 900 judges are being educated at one time. It's staggered, right?
It's half and half. So for instance, this is, we're in 2024, so there will be 2 segments of education conference. So you can't just, you can't take every judge off the bench, because that would just be, you couldn't do it. We need our judges in our courtrooms. So what we do, or what we have done, and I think continue to do, is half the judges in the state participate in the first part, the first session, and then the other half. So, and they're not, they're taken from all across the state, so that there isn't really, you can't shut down the branch of government. We have to have court. So we do it in such a way to have a little impact on the administration of justice or the disposition of cases.
Well, you were not only active in being a judge, you were also in the past on the board of directors for South Suburban PADS. I don't know what PADS stand for. You could tell me. It's a not-for-profit organization which delivers shelter, housing, and rehabilitative services to South Suburban Cook County's homeless population. So was that a volunteer position or a paid position for you?
No, there are no paid positions. No, my only paid position is being a judge. So PADS is public action to deliver shelter. And so in the Southland, not unlike the city of Chicago and other urban areas, there is a homelessness concern or issue. So I have been on the PADS board now since 2011. I'm a clinical social worker. Before I ever became a lawyer, I'm a clinical social worker. And some of the way that I address my passion for helping people is to serve on the board, which helps to provide services to that homeless population. So there's shelter, there is education training for them sometimes. There is really training on how to apply for a job. There are social services that can be made available. So I don't deliver those services. I serve on the board that oversees the delivery of those services to the homeless population here in the Southland. And unfortunately, we have in this country and in the Southland more homelessness than we really should have, I think. And I remain hopeful that governments across the country will find a way to end homelessness, because I think that America can do that.
When you talk about Southland, are you talking about the south part of Illinois, or because
Yeah.
this? Okay.
I am, and I'll clarify. So, we try to make a distinction between the south side of Chicago and the Southland. So when I say the Southland, I'm talking about the suburban areas outside of the city of Chicago. So some of the Southland would include villages like Homewood, Olympia Fields, Worth, the Blue Island, Orland Park, those things, those places.
What about Dixmoor? Because Dixmoor has been in the news so much now. Their water mains keep on breaking like 12 times or so in 1 or 2 weeks. It's does Dixmoor is a part of the Southland as well?
Well, it's part of the Southland, but it's not part of what we do with PADS. So PADS is really focused on the issue of homelessness. And I'm aware of the issue with the water issue in Dixmoor, and then hopefully that's going to be resolved in a way that is it keeps the residents safe. But I'm aware of Dixmoor. Dixmoor is a community that I would include in the Southland, but my work with South Suburban PADS is with the homelessness issue, not with what is going on with Dixmoor and the water issue.
Do you feel that how has PADS been able to make inroads on helping the homeless in the Southland?
Oh, I think so. I think so. But you know what? The best way, I'll know that we've been successful when I can say to you in an interview, there is no more homelessness. And until I can say that to you, I think we still have some successes to achieve. We've done a lot, I think, and there's been a spotlight really lately from governments all over the country. And I think you heard more about it during COVID, where people were being housed in hotels, the homeless, because churches were no longer available or able to house them, to set up shelters. And so we're housing people in hotels and building permanent shelters for people. So we've made some inroads, we've grown, but we still have homelessness. And until we no longer have homelessness, I will not say that we've been successful. We've had some successes, but we've not been successful.
You, in the beginning, you were a clinical social worker, and you decided to practice law and become a judge. Your main passion does seem to be to help people. How are you helping people as a judge? I know that you're deciding cases, but are you able to follow your passion and helping people by being a judge?
Oh, absolutely. Judges are public servants. We just serve in a different way. So I cannot reach out beyond the record and, talk to the people who are the subject of the appeal personally. But there are always ways that you're helping people. So there, in every case, and by now, in my 9 years as an appellate court judge, I've written more than 500 judicial decisions. Those are decisions that impact the lives of people. They're not just decisions that talk about the law. They're decisions that decide whether the sentence was too long, whether the sentence was excessive, whether this child was protected, whether this child needed to be better protected, whether the government should have introduced or should have released information, whether they should have withheld information. All of those things that I am still doing from the bench are ways to help and serve the people. I am additionally able to do that through my work in South Suburban PADS. Before that, I worked with Lawyers Lend a Hand for Youth, where I tutored every week a young student from Inglewood who had really actually never even been downtown, never had eaten out aside from eating at McDonald's. So there are lots of opportunities to still serve from the bench and off the bench. And I pride myself in being able and making myself available to do some of both.
I think I heard it from Judge Neil Cohen that he is trying to do rehabilitative services for defendants on day one when they first appear before him in court. Have you heard about that? Are you doing any of that as well?
I've not heard about that. Judge Cohen is absolutely a wonderful colleague and a wonderful slate mate, one who is running for full circuit court. And I know Judge Cohen, and I'm very fond of him and very fond of his work. He's such a wonderful judge with just great integrity, and I'm hoping for the best possible outcome for him in the March primary. In the appellate court, we're not able to reach beyond that record. We don't have generally litigants who appear before us personally, like Judge Cohen does in the trial court. In the appellate court, we are the reviewing court. Most of the folks who appear before us are attorneys, and the attorneys are arguing one side of an issue or another. So we know that there are people behind the issue. Of course there are. And people's lives are being impacted by the decisions that we make. And we're mindful of that. But we don't have the opportunities that the trial judge has to see and to talk to the defendant or to talk to the plaintiff up close and personal. We talk through our writing, through our decision making. And as I said, by now, 9 years now, I've got about 500 or so of those. So.
Justice Cynthia Cobbs, if our listeners want to learn more about you or maybe even contact you and ask more questions, how would they be able to do that?
So I thank you for asking that because it's so important now. And as we mentioned, we've got a primary election coming up on March 19th, 2024. Early voting is going to start March 4th. So I encourage everybody to do all of the research that you can possibly do on judges who are seeking to be elected in the first instance, or in my case, to continue my judicial service. So I have a website. It's www.justicecobbs.com. justicecobbs.com. So if you go onto my website, you can even volunteer to help in my campaign, but you can certainly put information out there. And my website gives you a lot of information about my professional career. So you can learn more about me. You can learn about my bar evaluations, which are important if you're voting. And if you don't mind, I'll offer that all of mine are the highest possible ratings that bar evaluations can give. And I've gotten wonderful endorsements as well. So I encourage you, www.justicecobbs.com.
Is there a form there in which people could email you, like like just a form, like a contact form?
If you go onto the website, there is a way to email. Yeah, there's a way to email. So you can sign up to volunteer. You can also email. You can send an email.
Wonderful. Well, Appellate Court Justice Cynthia Cobbs of District 1, thank you so much for joining us on WZRD Chicago 88.3 FM today. Good luck to you, and thank you so much for all your information.
Thank you. I appreciate being here. Thank you.
You're welcome.